Hello, my name is Edward Gross. I am the managing partner at the law firm of Gross & Romanick. You can learn more about our firm at our website at www.gross.com. Many businesses prefer arbitration over litigation in the event of a dispute or breach of contract. In fact, some businesses insert arbitration provisions into all of their contracts. Before you or your business can make a decision as to whether to agree or oppose insertion of an arbitration provision in a contract, you need to understand the pros and cons of arbitration. What are some of the advantages of arbitration over traditional litigation? Normal contract default provisions will require you to go to the court in the appropriate jurisdiction. You will be subject to the laws of that jurisdiction and to the procedures of that court. In an arbitration provision, you can describe in great detail how the matter will be arbitrated. The arbitration provision can designate what organization will conduct the arbitration and where the arbitration will take place. In our area of Northern Virginia, we have several arbitration organizations, including the American Arbitration Association, JAMS, and the McCammon Group. Each of these organizations have many fine arbitrators. You can define the qualifications of the arbitrator. For example, or if you are in the construction industry, you may want an arbitrator with construction experience. You may even want an arbitrator in the trade in which you are engaged in. If you believe that the dispute may involve computations of figures, you may feel comfortable with a CPA as the arbitrator. Many of these clauses require retired judges, and many retired judges do arbitration. You can determine the rules to be followed in the arbitration. JAMS and AAA have sets of rules that you can follow or not. You can describe the rules and the procedures in as much detail as you want. The procedural rules are generally more relaxed in arbitration. The intent is to make the process less formal and allow everyone to present all of their evidence without complex rules and restrictions. You can also make the arbitration binding or just advisory. Now, what are the disadvantages of arbitration? Arbitration is not appropriate in situations where you need immediate relief from the court. For example, a landlord would not want to insert an arbitration provision in a lease because you may need to evict a tenant, which an arbitrator does not have the power to do. Arbitration fees can be quite significant, unlike the court fees, which are quite low. Arbitrators are paid hourly, and you will have to pay an administrative fee to the arbitration organization. If it is a large arbitration, you may have to have 3 arbitrators on a panel and pay hourly for all of those arbitrators. The arbitration organization and the arbitrators generally require all of their money up front before you can go to the final arbitration hearing. If you are the party that is aggrieved, you may need to advance all of the fees, including the fees for the other party. The other party may not be willing to put up any fees because they may not want to go to arbitration. While you may receive an award of the fees for arbitration, if there is such a provision in your contract, you may find that it is difficult to collect those fees after the arbitration. Discovery is generally limited in arbitration. If you do not have your proof in advance, you may find it very difficult to obtain it through the arbitration process. Attorneys' fees are not generally much less in arbitration than they are in court. The savings are often very moderate. Arbitrators do not always leave the perception that they are good judges. Many arbitrators have limited training or experience. While many arbitrators are very good, the loser often feels that an experienced judge in court might have done a better job with their case. Each situation is different. The decision to insert an arbitration clause in your contract should be made in consultation with a lawyer. Our firm has experience in litigation and in arbitration. We have found advantages and disadvantages to both. If you would like to contact our firm, please call us at 703-273-1400, or you can visit our website at www.gross.com.